So tonight we're going to do a wine and wills. Kind of the intent of this is just a casual kind of informal get together where I try to share some information about the estate administration and probate process. You know, the same advice I'd give my own mom. And I like my mom, for the record. So I want to give you an introduction, some administrative items for Zoom, our presentation, and then some time for questions at the end. So a little bit about myself. My name's Chris Hall. I'm an attorney out here in Lakeway, Texas, with the Thrash Carroll Vanway Law Group. I've been working for Aaron about 2-3 years now. And before that, I worked for another fellow out here for about 8 years. So I'm coming up on, depending on my math here, about 12 years working in estate and probate administration. I did a bunch of tax work for the last guy I worked for. So I did a lot of income taxes and death tax planning. And I got a certified financial planner designation, so I can help you guys with investments if that comes up. With Erin, I've been working for her about 2-3 years now, and I'm now board certified in estate planning and probate law. So try to be helpful to you guys tonight. Moving on to some administrative items for Zoom tonight. If possible, I'm gonna try to limit verbal questions until the end. So if you'll mute your mic to prevent crosstalk, right? Because if we got like dogs barking in the background or something like that, it can be hard for people to hear. You might see a chat function in your Zoom interface, and that will let you type questions to me. And that I can see those questions and respond to those questions as you think of them, right? You don't have to wait until the end to type a question. I want you guys to know that we're recording this so that we can post it on our website and on YouTube. So if you want to not be on the internet, look for the button to zero out your camera. And if you ask questions, you can make them kind of anonymous, sort of, I'm asking for a friend. So then the standard disclaimer here is, I want you to know that the information I'm giving you tonight is as accurate as I can be, but it's general in advice. It's generic advice, right? If you want advice specific to your situation, please have a meeting with us so we can give you advice to your specific situation. Otherwise, what we're doing here tonight is kind of informal, and what we're doing is just general advice, no attorney-client privilege, no attorney-client relationship from this presentation. Okay, I am gonna start the presentation. I think that you guys see the cover page for the presentation on your screen. If not, type a nasty message to me in the chat. We're gonna start going. Okay, so our meeting today is 5 things everyone should know about probate in Texas. I'm gonna try to give you actual case studies from anonymous clients of things that we actually see at the law firm. So you guys can kind of see what we see, and you can learn from other people's misfortune, so it doesn't have to happen to you. Okay, so here's the big picture overview of what we're doing today. What is the probate and estate administration process? What does that mean? How does that affect you and the people you care about? What are the requirements for a valid will in Texas? And when I say valid will, I just mean the minimum requirements. It doesn't mean you have a good will, but at least you have an effective legal will. Then I'll give you 5 case studies, 5 real-life examples of what happens in the probate and estate administration process. And then finally, some people don't want to go through probate. Some people don't want to do that process. If you want to avoid that process, we'll show you how. Excuse me. So what is probate? When we say probate, what does that mean? Probate is a fancy way of saying the process where a judge evaluates a will, looks it over, and says, yes, this will meets the requirements of the Texas Estates Code, and I'm going to sign an order that says, Judge Guy Herman has reviewed this will and it's effective. It's legally valid, and I'm going to name somebody with legal authority to sign for the assets of someone who's deceased. Example, sign for a deceased person's bank accounts, which are frozen now that they're dead, or sign for a deceased person's real estate now that that person is dead. You'll see a third bullet, get letters testamentary. Letters testamentary are a fancy word for a piece of paper that's issued by the court that says the will is valid and George can sign for the assets of the deceased person. So let's give you some examples. Let's keep going. Why would you probate a will? Why would you go through that effort? Because it's a court process, right? You hire an attorney, it costs money, it takes time. Typically what you're doing is when somebody dies, their assets get frozen. So their bank accounts, when the bank finds out that person is deceased, they freeze the account. They don't let anybody in. When somebody dies and a title company finds out that the owner of the real estate is deceased, they typically won't let you sell that property until they have an executor who has legal authority to sign for that real estate. So typically the reason you go through probate is you say, I got frozen out of some assets. Now I need to prove that I'm executor so I can sign for a deceased person's assets and then transfer those assets to the right people, right? Because otherwise they're just stuck. So a little background. We got to talk about, before we even go to court, before we visit Judge Guy Herman in Travis County, do I even have a will to begin with? Do I have a valid will? I'll tell you a shortcut. We'll do the will for you. But if you're doing a little self-help at home, here's how you know whether you have a will. Now, when I say whether you have a will, I just mean, do you meet the minimum requirements for a will? It doesn't mean your will is like well drafted, but it is at least acknowledged as a will in Texas. So there are 3 types of wills. Texas only acknowledges the first 2. You've got an attested will, which is a will where the person who's making the will signs it, and 2 witnesses signed it as well. And you've got a holographic will, which is a handwritten will that doesn't have witnesses. And then Texas doesn't acknowledge the third one, which is a non-cubitive will, which is like a verbal will. Some states let you make a verbal will on your deathbed if there are certain circumstances are met. So let's look at those valid wills. What is an attested will? An attested will is kind of the gold standard in Texas. When you're making a will, you sign it and you have 2 witnesses sign it with you. So let me give you an example. Is this a valid attested will? I'm going to pose this question to you guys. Feel free to comment in the chat box. I'm curious to see what you think. The will reads, I leave my entire estate to my wife. That's Anna Nicole Smith right there. It's signed by the husband, January 1st, 2020. There are 2 witnesses to the will. They sign it. One of the witnesses is the wife. Is this, oh, and there's no notary seal on this will. There's no notary stamp or signature. Is this a valid will in the state of Texas? What do you guys think?
No.
It is a valid will here in Texas, but there's a caveat here. I threw in a little wrench in this story. The wife is a beneficiary under this will, and I want you to know why that matters, because if you have a friend who does a self-help will, this is important for them to know. When you have a witness who receives under the will, like the wife, if she's a witness, the Texas Estates Code says, wait a second, she receives under this will? She is an interested party. She's got a dog in this fight. So we're going to possibly reduce the amount that she receives under this will. So if you've got 2 witnesses on your will, you don't want them to receive anything under your will. So you'll see that in our law firm, when we have witnesses sign your wills, witness your wills for you, they never receive under your will. That means they're an independent witness, and that's what you want with a will. Let's go to the next type of will. What is a holographic will? A holographic will is solely in the testator's handwriting, and it's signed by the testator. No witnesses are required. So, in this case, let me give you an example. Farmer Bob is on his ranch. It's a big ranch. You can look out, far out, and not see anybody. Wait, somebody's texting me. Sorry, you guys. Okay. So, Farmer Bob is kind of like me. He's a motorsport enthusiast, so he takes a corner too fast, and the tractor falls over on top of him, and he's pinned. He's pinned underneath his tractor. And he yells and he yells and he yells. He's trying to get somebody's attention, but nobody's going to find him. And he realizes, I'm going to die here. Nobody's going to find me in time. So what he does is he scrawls out in blood on the side of the tractor, I leave everything to my wife, signed Farmer Bob. Is that a valid holographic will in Texas? What do you guys think? Yes? No? Yes? No? The answer is yes. This is a valid holographic will. It went to court. It was litigated. Apparently, he was worth a lot of money if people fought over it. And this is a valid will. For our purposes, if you are friends without a will, they can do a it's not our top recommendation, but if you need a will in a pinch, you can do a holographic will. But it's usually not our first choice because typically you're going to be missing a lot of provisions in that holographic will that you have in a formally drafted will with a lot of the standard boilerplate provisions. So let's go to case studies. We're talking about 5 things that everyone should know about the probate and estate administration process in Texas. So I got a case study for you guys. JR and Sue Ellen Ewing buy a ranch. I think you might some of you guys might recognize these people. JR's will says, I want to leave 100% of everything to my wife, Sue Ellen. This is a valid will. You can assume the will is valid. Husband J.R. Ewing dies mysteriously during divorce proceedings. So he passes away, right? And Sue Ellen is alive. Now that J.R. is deceased, can the surviving spouse, Sue Ellen, sell the ranch? Does the house go to Sue Ellen automatically? What do you think happens? Can she sell the house? I'm gonna let the suspense build a little more. Do you guys know how to use the chat function on your Zoom interface? Do you see the chat function? I'm kind of curious to see what you guys think. Okay, I'll tell you the answer. Hannah says, I don't think so. Sunny says, yes, of course. Jennifer says, yes. Peanut Gallery, who else? Okay, there's a hitch here, okay? There is a hitch here. They bought it as husband and wife, right? In Texas, the default presumption is that if you buy property as husband and wife, then it's community property. That means JR owns half, Sue Ellen owns half, right? So let's say Sue Ellen finds a realtor, right? She gets a realtor. Realtor goes and finds a buyer, right? And the buyer shows up. The buyer says, okay, I'm interested in buying the house from you guys, right? That's when a title company gets involved. And the title company is going to check the deed records. And the most recent deed is going to say the most recent owners of the house are JR and Sue Ellen. So the title company is going to say, okay, look, this is community property because none of the exceptions to community property apply in this case. So Sue Ellen, you can sign for your half of the house. So you own half the house, you can sign for half the house. But where's JR? Why isn't he here? She'll say, well, he's dead. He can't sign. I'm his wife. His will says, give everything to me, right? She shows them the will. Oh, I gotta let somebody else in. Admit. Here's the will, right? Here's his death certificate. Take a look at section 3.03. Everything goes to me. Here's what the title company is gonna say to that. They're gonna say, we are not in the business of reading wills. This is a very dangerous business for us. We don't know you from Cain. Sorry, we don't. And nowadays, people can make bogus documents so easily with Photoshop, with computers, with color printers. So they're going to say, we cannot sign off on that, right? Because we have no idea who's authorized to sign for JR. Maybe he has 6 kids from a prior marriage who say, nope, we don't agree with this. That's a bogus will. So what the title company is going to want to see is they're going to want you to go through the probate court process for JR's will. They're going to want to see a probate judge's signature saying, I've evaluated the will. It's a valid will under the laws of the state of Texas. And I named Sue Ellen as executor under the will to sign for JR. Until that happens, nobody has signing authority for that, for JR's half of the house. It's just in limbo. Now, does that surprise any of you guys? Okay, I'm fishing for comments in the text. I'm fishing for comments in the text section. So I want to point out to you guys something that I threw into this example here. Does it bother any of you guys that JR died while he was in divorce proceedings with Sue Ellen? Does that seem strange to you guys in any way? Yeah, okay. So there's a rule in Texas, and I tried to trip you guys up on this one. There's a rule in Texas is that if you are divorced from somebody, then Texas, to the extent that state law allows it to, will remove your ex-spouse from your will. But you see, in this case, I threw a curveball for you guys. They were in the midst of divorce proceedings, but they hadn't actually gotten divorced yet. It had not been completed. So in this case, when JR's will says, I give everything to Sue Ellen, his will can still leave property to Sue Ellen because they were still married when he died. They had not finished the divorce. So the moral of the story there is, with divorce, if you're thinking about divorcing somebody, you should, or a lot of times if it's one of your kids, for example, is thinking about divorcing somebody, you should get them to update all their documents right away and not wait for the divorce to finish. So I'm going to go to the next slide. I got another mean case study for you guys. Oh, okay, I got a question. Okay, Hannah is asking, what would happen if my father has passed and my mother still lives in the home they bought together and they have a shared bank account? Will that cause any issues? Can you guys see Hannah's question in the chat? I think. Look around in your Zoom menu and see if you can bring up the chat function. Okay, so you see Hannah's question there. Thanks, Jennifer. So, Hannah's saying, mom and dad live together in a house, right? they bought together and they share bank account, and dad dies. Does that cause any problems? That's pretty much this case right here. Because the difference in Hannah's case is that mom continues to live in the house, right? She doesn't want to sell it. She just keeps living it. So far, so good. You know, they say possession is 9/10 of the law. But eventually, she will want to probate her husband's will if she wants to get a mortgage on the house or she wants to sell it. Because before she can sign for the house, she needs to get signing authority for her husband's share of the house. So usually when somebody dies with real estate, you need to check to see, can I get signing authority for his half of the house? And usually you have to go through probate to do that, unless you have a trust. Gary Armstrong's got a comment. What if the account is set up as transfer on death, TOD? And that's a good one right there. So, Gary, you are jumping ahead. I acknowledge what you see right there. You're
okay.
you're getting ahead.
That's all right.
You're anticipating, but that's good. I like that. You're drinking some wine. That's the whole purpose of being here. I'm going to go to the next case study because we addressed your question, Gary, further ahead.
Okay.
Okay. Case number 2. This is also another common case for our clients, right? Especially out here in Lakeway. A lot of our clients, a lot of their wealth is either in real estate, like their house, but a lot of our clients, a lot of their wealth is in their 401k account or their retirement accounts, right? It's usually one of those two is common. So, case number 2. Father has a 401k of $1 million. That's, you know, we just pull the number from the sky. We want it to be a big number, right? So it kind of matters. So, Gary, you anticipated this one really well. The 401k beneficiary designation says, I leave everything to my wife. That sounds pretty normal. That's very common. Makes a lot of sense for tax planning and for your spouse. Makes a lot of sense to do that. But there's a twist. Father divorces the wife in Texas. They get a divorce. Now, in this case, it's not like the prior one. They actually finished the divorce, right? The family law judge says, yes, you guys are divorced. Decree of divorce, it's filed. Father says, okay, I want to update my will. I just got divorced. That is a good reason to update your will, by the way. It's a very good reason. And he updates his will. And he says, I want to leave everything to my only daughter. That makes perfect sense. Good plan, right? Father dies tragically. Tragically. Have you noticed in Disney movies that the kids never have parents? Somebody just pointed that out to me. It never occurred to me. Okay, so father dies tragically, right? And he died. He's deceased. Ex-wife has a death certificate. Daughter has a death certificate for dad. Who gets the 401k? It's $1 million. It matters, right? Who gets that 401k? I'm going to step away and hopefully see some comments in the text messages. I see 2 votes for ex-wife. Do you guys see that? Oh, we have some division here. I like this. Stirring the pot here, you guys. I'm just eyeballing it here. It seems about 50-50. Ex-wife, daughter.
Has the will
okay. Okay. We know that father, both. That's a good hedge. Jennifer says both? There's a question mark. We know that father intended to leave everything to his daughter, right? I mean, that's pretty clear. You went through the trouble of updating his will, right? But there's a nasty little catch. Gary, I see you shaking your head. You're right to shake your head. This is a trap. This fact pattern is a trap. It's been litigated here in the Fifth Circuit, and some of you guys may not like the result. Remember how we said earlier, if you get divorced, Texas state law. Remember, we got federal and then we got state, right? Although we are the best state in the union, there is still federal law above us. We can't change that. So the Texas Family Code will say, you got a valid divorce? Perfect. Okay. I will, to the extent that state law has power, it will remove ex-wife from the will. And he already did that with his will. But there's a little catch here in this fact pattern. You notice I said it was an ERISA plan. Mm-hmm. ERISA is federal law. That trumps state law. So it's governed by federal statutes. And when the Fifth Circuit looked at this case, they said, hey, this 401k plan is governed by federal law, not Texas law. And federal law says if you get divorced, the beneficiary designation is still in control. It doesn't matter if Texas gave you a divorce or not. We don't care. We're the feds. We don't care what you do. And the federal statute says for a 401k, we don't care what the will says, and we don't care if you got divorced. If you left your beneficiary designation to your ex-wife, it doesn't matter. It goes to her. And daughter is, pardon my French, you guys, I feel bad for her, right? She's up the creek without a paddle. She's got no recourse here. So here's the moral of the story, especially if you're talking to your kids or to your friends, right? When you are in a dicey marital situation, you need to not forget about your retirement accounts or your life insurance or your annuities, because those are assets that are controlled by a beneficiary designation. And a beneficiary designation doesn't care what your will says, right? They don't care. It's a contractual obligation. The 401k company, the IRA, the life insurance guys, they're going to say, we don't want to read the will. We're not interested, right? The guy who opened this account told us in the beneficiary designation form, when I die, give it to my ex-wife. That's all they care about. So it got to the Fifth Circuit. So the people who fought this, they spent a lot of money fighting this. So they stumbled up on this one. I don't want this to happen to any of you guys. All right. You guys ready? Take a sip of wine. You're going to need some alcohol for the next one. The next one's rough. I'm going to take a sip. Okay. So the next one is, what happens if I die without a will? What happens if I die without a will? I confess that I'm a little biased. I don't recommend it. I am in the business of writing wills, but I can tell you, if my mom came up to me and asked, should I die without a will? My answer would be no. And I'll tell you exactly why. Because at that point, you have no control over what happens to your assets when you die. Basically right. Texas, the state of Texas has a Texas Estates Code that says when you die without a will, there's a formula. And it just plugs everything into the formula. You might like what happens to the formula. In some cases, it gets it right. Like usually, if you only have one wife and your kids are only from that wife, you typically want it to go to your wife and your kids. That's a good result. But where it really falls off, where the formula can't really anticipate what's going on, and this is important for your friends, is if you have friends or family or kids who have kids from a prior marriage, right? They have kids from marriage number 1 and kids from marriage number 2, you really don't want this default rule to kick in. And I'll show you why. The next slide, I'm going to show you the distribution formula. Is going to be kind of small, and I'm going to just focus on a small part of it. Okay, let's take a look. I know it's kind of small. I don't know if you can see it. I'm going to zoom in a second. This is a PDF from the Travis County Probate Court. So that's Judge Guy Herman downtown, right? 1000 Guadalupe. He's got a PDF on his website that tells you if you die without a will, here's where your stuff goes. So what I'm seeing on my screen is 4 pie charts, right? And And he simplified it for you. It can get a lot more complicated. I'm going to use the magnifying glass function to try to show you just the community property portion. I think you guys should see decedent share of community property. I think that's what you guys should see. Now I'm going to simplify it for you. How your property passes if you die without a will depends on your family tree and the nature of the property you own when you die. I'm going to simplify it for tonight is that the general rule is that when you have property and you're married to somebody, it defaults to community property. And I confess that sometimes I like to go online and see what self-help people get online about dying without a will. And I find that when I search Google, it seems that most people, the word on the street, this is not what happens legally, but the word on the street is that when you die without a will, everything goes to your spouse. And the answer is, it depends. Take a look at this box C right here. This assumes you die and you have kids, and it says all of your surviving children are also children of your spouse. Let me give you a concrete example. Fred is married to Susan, right? Fred is married to Susan, and he has 2 kids, and those kids are also kids of Susan, right? So they're a normal nuclear family, right? My only kids are kids of my only wife, right? In that case, the statement is true. All my community property would go to my wife. And in a lot of cases, that would be what you want, right? But let me give you a different scenario. Let me zoom out of this.
It changed.
Do you see that now? We go to a different C. It says decedent share of community property. So this is Fred, and he's married to Susan. Fred is deceased, okay? He has 2 kids. When there are children or other descendants from outside of the existing marriage, that's the blended family situation. So that case is contemplating Fred has kids with Susan, but he also has kids with somebody else, right, from a prior spouse. And you see what it does there? It says all of Fred's community property to his children. And Susan keeps her half of the community property. So that means Susan doesn't get everything. Susan keeps her 50%, and Fred's 50% goes to his kids, his 4 kids, 2 from the prior marriage, 2 from his marriage from Susan. Gary, I see you with like your fingers against your forehead. That's exactly right. No, that's normal. That is what most people say when they see this information. They go, what? And that's my experience too. When I tell most clients this is what happens if you die without a will, a lot of them say, well, that's not what I would have chosen, right? And that's my experience with most of my clients too. So the takeaway here is I really don't think you should die without a will if you can avoid it. Now, I'm a little biased since I write wills, but I think that's still good advice. Okay, so let me go to the next slide. I'm going to do 4 case studies here, okay? And I'm just going to focus on 2 cases right here. Let's say we've got a husband and a wife, right? I think that's what you can see. And husband is deceased, and he's got kids from a prior marriage. So he's got 2 kids from a prior marriage and 2 kids with his current wife, right? So we've got kids, current wife and past wife. I'm only going to look at these community property questions right here. Let's say he's got a husband and wife have a ranch that is community property, right? I'm just going to look at this one. They own a ranch as community property, and he dies without a will. What happens to the ranch? I'm going to show you the chart from Judge Guy Herman, and I wonder what you think about the result. Here's the chart for decedent share community property, right? Remember, Fred died. He has 2 kids from a prior marriage. 2 kids with his current wife. It says all of his community property to his 4 kids who share it equally. And then Susan retains her community property half in the ranch. What do you guys think about that? Don't worry. If you don't know what to say, when I learned about it in law school, I was stumped too. I didn't believe it at first, but that's what it is.
Will you say it again, what the outcome was?
Yeah, okay. So you've got a ranch, right, that husband and wife bought as a married couple, right? So I'm going to give a number to this ranch. Let's call it worth $100,000 to make it nice and even, right? Then he dies without a will. So he owns $50,000 and she owns $50,000 of the ranch, right? Because they each own half. Now what happens to his half, right? Because he owns half the ranch. His half goes to his 4 children in equal shares. And Susan retains her half of the ranch. I know that seems really strange. That's an answer only a lawyer could love. But that's what the code tells us to do. I've got a comment from Teresa. Let's see what Teresa says. Teresa says, seems fair since his second wife may hate the kids from the first. Yeah. You might have a situation where the stepkids and the second wife don't get along. And he didn't designate if he wanted her to get it all. Yeah, that's definitely one of the conclusions the legislature could have come to. Yeah, absolutely. So, guess what? I told you guys to get a sip of wine before we did this case. This case number 3. If you guys are stumped, I don't blame you. I had to study for this too in law school. So, the moral of the story though, is if you can help it, especially if you have kids from a prior marriage, or your kids have kids from a prior marriage, or someone you know is in that situation, don't let them die without a will. They should really talk it over and figure out exactly what they want to happen if they die, and not let the state of Texas decide for them. All right, you guys ready? Stretch, move around a little bit. Let's go to the next case. I think you should see case number 4, minor beneficiaries. So kids under 18, right? Single father. So we're getting away from this divorce problem, right? We just have someone who's single. I'm trying to make it easy for you guys, right? Single father has a 401k, this time $1 million again. His beneficiary designation says, to my children in equal shares. To my children in equal shares. All of his children are under the age of 18. Mm-hmm. I forgot to add this bullet. He dies. Sorry, in probate, somebody's got to die. He passes away. Can the children access their inheritance from the 401k? Why or why not? Gary, I see you shaking your head. What does everybody else think? Give me some comments, you guys.
No.
Minors. Yeah.
They're minor. They have no legal standing to the money.
Gary, I can't let you into these meetings anymore. You know all the answers.
Well, I was executor for an estate for 4 years, so I saw a lot of this stuff. Sorry about that. I don't mean to.
You look at the questions, I go, this man knows what's going on. He's got an advantage on everybody.
No, there's always something to learn, so, yeah.
Yeah, you heard it from Gary. Gary nailed it right there on the head, right? They're under 18. That's the problem, right? So there's the question, can they really like hold custody? Well, aside from the fact of whether it's a good idea for them to have that money, and I don't think it's a good idea. as a legal matter, they can't really hold custody to that money. The default procedure would be you would need some sort of guardian appointed for them to hold custody of the money. Because I think the custodians that I've seen, like let's say it's Fidelity, right? Fidelity gets the death certificate, right? And then they say, oh, the beneficiary designation says to these 4 people, right? One of the questions they're going to ask is, how old are you, right? Because we want to know if you're a minor or not, because we can't just give it to you if you're a minor. And I think the custodians I've seen is they would say, you're a minor, we can't give you the money. We can give it to your guardian if there's some sort of custodial arrangement set up, but typically they're going to look for a guardian. So the moral of this story is you typically don't want to leave assets to minors directly. It just causes all sorts of problems. Catherine, I see your comment, Catherine Woods. Exactly, you nailed it right there on the head. Typically what you would do is you'd say, I've already thought of someone who I trust to take custody of the money and hold it in a savings account for them and manage it for their benefit. That's a trust, basically, right? Someone is holding money for the benefit of somebody else, subject to certain written instructions. So yeah, in an ideal world, what father would have done is he would have had some sort of trust arrangement set up for his kids beforehand. And then his 401k would say, to the trustee of my trust for my children's benefit. But without going into the trust administration issues right here, the moral of this story, and you hit it right there, Gary, Catherine, you guys hit it. You don't want to leave assets to minor beneficiaries outright. It's just a recipe for disaster. I'm gonna do a little sidebar right here. When I was working in my prior job, I was doing a lot of tax returns, and we had more than one case where, you know, he wasn't 18, but he was just over 18, and he inherited some money. It's a pretty substantial amount of money from a personal injury lawsuit. He got a fast sports car, wrapped it around a telephone pole. You know, that kind of stuff happens. So you don't want to leave, even if you could leave money to young kids, I still wouldn't recommend it. Okay.
Chris, explain to what a guardianship proceeding would look like and what that means.
Okay. So guardianship proceedings are also, oh, I've got another person to add. Sorry, Shelly, if I left you out there so long. So guardianship is a lawsuit. It's handled in the probate court with Judge Guy Herman downtown. And literally what the application says is this person is not competent to manage their own money. So I want you being Judge Guy Herman, I am petitioning you to name a guardian to have signing authority for that person's assets. I want you to be able to sign for anything in their name, right? So that's typically a lawsuit. You sue the person, right? You drag them into court. And then the judge decides whether he wants to appoint a guardian to have signing authority for that person. Usually for kids, that's no big deal, right? The judge will say, yeah, that makes perfect sense. Sean is age 17. You want to have someone hold money for him? Yeah, that makes perfect sense. Typically, I wouldn't recommend going through the guardianship proceeding if you don't have to, because, forgive me, as an attorney, I love receiving money. That's part of being an attorney, but I don't want your money if I'm not really helping you. So typically what you would do to avoid the guardianship process is you would think to yourself, if I were not here today, right? If I couldn't be there for that child, who would I trust to hold money for that child's benefit until they say hit age 35 or something like that, right? You'd say, who do I trust to do that? Then you would just draft, well, you'd hire us. We draft a trust document that says, I trust Fred to look after my kids. So I'm instructing Fred, if I give him money in trust, he's going to open up a trust checking account. And that trust checking account, he's only going to use for the benefit of my kids. And under certain conditions, like for them to go to college or for medical bills. Excuse me. And then you typically put a termination provision on the trust. And it says, say, when they hit age 35, they're probably as mature as they're going to be, hopefully. So then the Fred can distribute their share of the trust to them. I hope that answered the question.
Yeah, Chris, I was just trying to also wanted to mention that guardianship proceedings are not cheap. You're guaranteed to invest your money in something that earns a very safe but almost zero rate of return, and will be administered in a very expensive process. So a lot of times we see young kids at 2 and 3 inheriting $50,000 that's administered in a trust, and by the time they turn 18, the trust administration fees or the administration fees of the guardianship burn up all the money. So not a good way to handle that.
Very excellent point. Excellent point right there. Yeah, could not agree more. Could not agree more. Oh, okay, it looks like we got a question from Marcia. Let's take a look at Marcia's question.
On.
Well, they're moving. It's not frozen up.
Marcia, I see your question. Okay, that is beyond the scope. That's beyond the scope of tonight's conversation. But send me an email. Okay, send me an email. I can help you out with that because we got to go deeper into the chart to figure out who gets what. But thank you for the question. That is a great question. Okay, you knew what was going to happen. When you talk about probate, when you talk about dying, you can't just talk about dying. You got to talk about taxes. So we're going to talk about federal estate taxes right here. Okay, so this is kind of a good time to talk about it because federal estate taxes are in flux right now. So take a look at that chart in the lower right. You should see a year and you should see the estate tax exemption level, right? So for 2017, oh, let me define the estate tax. Sorry, I'm just jumping ahead, you guys. So the federal estate tax is a tax that is imposed on your executor when you die. So it only happens when you die. So what the federal estate tax does is they say, hey, executor, you need to file if the person who died has sufficient assets. That's what the table is. If they have enough assets when they die, I want you to file an IRS Form 706 death tax return. I want you to produce a complete balance sheet for this deceased person so I can know what that person is worth as of his date of death. Well, that's, you know, if you have a complicated estate, right, you've got a lot of assets, that can be a lot of trouble, right? And then to add insult to injury, what they'll do is they'll say, if your assets, if your net worth is over the exemption level, we are going to tax you on 40% of each dollar over the exemption level. So 40%, that's pretty nasty, right? But fortunately, some of you guys remember when the estate tax exemption level was really low. It was $600,000, $700,000. So a lot of us out here in Lakeway, right? You're just a normal, hardworking guy who saved his life, right? But he's got a house and a big IRA. He's easily at $700,000, right? So what happens is if you're over the exemption level when you die, you could be eating a 40% tax for every dollar over the exemption level. But there's a nice part of this. Look at the chart right there. Look at 2017, right? You should see an exemption level of 5.49 million. And then in 2018, it jumped to 11 million, you know, just 11 and change, right? And it's steadily going up with inflation. So for a lot of our clients, you know, a lot of us normal people are not going to hit $11 million. Tell me if you do. But we have some fine print in the lower left. There's a sunset provision. On January 1st, 2026, the estate tax exemption level is scheduled to sunset, and this is before the inflation adjustment, so I'm just making the number simple. Before inflation is set to sunset to $5 million. So that's going to hit a lot more people than $11 million. Let me give you a case study. Oh, let me go back. I'm sorry, Catherine. Let me make the chart right there. Can you see the chart now?
Yes.
Yeah. Okay, so you see it basically doubled from 2017 to 2018. And it goes up. Oh, I'm sorry, Kathy. Okay, we'll go to the case study, and I'll just tell you all the numbers. We got less numbers to work with on the next one. Okay, case 5, Susan.
Okay, let me call you back. I'm on this Zoom thing.
Oh, I'm sorry. Say again.
No. Okay, bye.
Okay. All right. Oh, we're coming up on 7:30 pretty quick. Okay. So Susan, who is single, dies on December 1st, 2026. Her net worth on her date of death is $10 million. Assume for right now the estate tax rate is 40%. She's going to get taxed 40% on every dollar that she's worth over the exemption level. Assume that the new estate tax exemption in 2026 is $5 million. How much in estate taxes does Susan owe Uncle Sam?
40% of the 5 million.
Yeah. 2 million.
Answers? You want to type them out?
She died before the new exemption went into effect. She doesn't apply.
Everybody's saying 2 million.
Mhm.
Yes, perfect. You guys are all getting it. You guys are, I hope you aren't just like copying other people's answers. Yeah, that's it, right? Because we know the estate tax exemption level is 5. She's over it by 5. So you take 40% of 5 million, which is, I don't know about you, but I'd rather not cut a check to Uncle Sam for $2 million if I don't have to. That is not a fun check to write. So the reason I bring that up now is because if a certain political party wins the election, they may want to repeal the estate tax exemption early. They may want to repeal it back to January 1st, 2021. So if you or anyone you know is kind of in that area right there around 5 million, then they might want to get a new balance sheet and then start thinking about updating their estate plan. Okay, you guys, there are a few more slides, but we are coming up on time. So I'm going to just do your questions now. I got a question from Dixie. Let's take a look, you guys. See if you guys can see it with me. I have a revocable trust. When I die, everything will be equally divided between my 2 children. Would a will have been enough instead of the revocable trust? Let me let you guys have a chance to read that.
Should have been. But probably isn't. That's all we know.
Dixie, that is a great question. That's a really good question. And for that question, when you have a revocable trust, we like a lot of our clients to have revocable trust to avoid the probate process. Because when you go through probate, you got to hire an attorney like me, right? And then it's about a 2-month process, and that costs money. And I'm happy to get your legal fees, but if we can avoid it, we should, right? The devil is in the details there. If you have a revocable trust, and the and is important here, and you have all your assets set up so they are controlled by your trust or passed consistent with your trust, then the will never needs to be taken to the probate court, which is usually the reason you do a revocable trust, to avoid the probate court process. Typically, when we do estate planning or you do a revocable trust with anybody else, they will typically have you do a will anyway as a backup. Because oftentimes, even with the best homework, right? Sometimes there are things that surprise you. I'll give you an example. Yeah, so good. Do you see Dixie's comment? Yeah, it was done by Thrash. Yeah, we did a will for you too. Typically, sometimes what happens to our clients is they realize that they have an asset they didn't know about that was not controlled by the trust, and then they die. Common example would be long lost mineral interests, utility refunds, and for those things, you just don't know about them. So it's nice to have the will as a backup anyway. Okay, Dixie, I hope that helped. All right, I got another question from Gary. Thank you. Let's take a look. If you have a will with property designated to go to a sibling acquired prior to a marriage, who does the property go to? If you have a will with property designated to go to a sibling acquired prior to a marriage, who does the property go to? Gary, you are way ahead of the class here. Okay. Gary, I think the issue you're raising is separate property acquired before marriage?
Right.
Okay, perfect. So yeah, if you look, and I think it's one of the first articles in our wills, but it's a standard boilerplate provision. It'll say, my will disposes of my separate property and my share of the community property, right? So if in this hypothetical, if you have a will and you own separate property, right?
Right.
And your will is valid, right? I'm going to assume it's valid. Then it can definitely dispose of your separate property.
Okay. Okay.
Yeah, absolutely.
Okay.
We don't have none of those. We have none of those dying without a will problems, because your will just steps in and says, I got it.
Right. Okay.
Although we do have one important qualifier on that, Chris, which is if the piece of property that you're giving away is your homestead, we got a little different wrinkle.
Well, that is the case. Okay. So I should have.
So even if your property is your separate property, which you give to your spouse, that you give to your sibling, if it's the homestead, your spouse, even if it's your separate property, will have the right to live there by making a homestead claim for the rest of her life, and then your sibling will own the remainder interest.
I should have qualified that. Thank you.
Well, it's just one of those little exceptions. We get hit with a lot of these, so I just kind of wanted to jump in there.
Oh, by the way, you guys, you'll notice that was Mike Carroll of Thrash Carroll and Vanway. So you got some heavy hitters answering your questions here.
Thank you, Michael.
Are you saying I'm fat?
Hey, you've been working out, Mike. You're looking good. You're looking good.
Working out at the dinner table.
Okay, you guys, I think let's go for, we got time for one more question, I feel like. Any questions out there?
About 20 acres.
Okay, I think that'll be good then. You guys,
You have to run.
it's been really great having you guys here tonight for a Wine and Wills. If you want a copy of my presentation, let me just type in my email address.
That is separate property.
Yeah. It's covered in there. I think it's all covered.
I'd be happy to email it to you. And if you've got any questions that you want to just ask privately, please feel free to just email us at and one of the attorneys here can like schedule a time to talk to you and like go over your specific questions. It's been really great having you guys here. I hope this has been helpful. I hope you guys liked it. Hopefully we'll be sending out another invite maybe a month from now or so to see you guys. I've had a lot of fun. I hope you guys did too.
Yes.
All right, you guys, I'm going to close it out. Have a great night, you guys.
Oh.
Leave.